So first up on the Rekieta case. So what's interesting is is how much that case is a crash course in the law. The latest is that documents appeared to have been leaked that were sealed juvenile family court files concerning minor children, and including the medical records about any drug testing they had undergone. The extraordinary thing about that is those records are like the most sealed records on the planet. They're even more sealed than grand jury records. So they're about as secret as you can possibly get. The release of them violates a range of crimes, state crimes as well as potentially federal crimes, because they concern HIPAA records. What it reveals is multiple things. The nature of family services, children's protective services, as they're mislabeled in many states. Reveals something about what's going on in the Rekieta case, confirming certain suspicions that I had that I was criticized for by LawTube. How it is you can use documented information to read between the lines. If you're able to discern motive, then you're often able to predict what's going to happen, and also guess more accurately what evidence is there or not there in any particular matter. In fact, I used this methodology in 2 major cases that unraveled major government conspiracies in those cases. And I'll go through how you can learn that tact or trait yourself. The nature of drug testing. I'm always fascinated by people who believe that if it's a scientific test, Robert, it's completely reliable. Even when there's many, many reasons to doubt that. The wonderful thing about COVID is it drastically increased people's skepticism of government lab tests. They just went through this Amos Miller case where they were trying to scheme every means available to create a fake result, a falsified test. And we'll go through that. Because it's a crash course in that aspect as well. A crash course in how the state uses threats to take away your children to get you to forfeit your rights in a parallel civil or criminal case. They do this all the time. And that's partially what's taking place here. And it also relates to something we've been talking about on the show now for years, which is what's really going on in the Children Protective Services space more broadly. You may remember us talking about various foster care organizations, adoption organizations, filing suit over, and we've talked about several of those suits. One of them reached the Supreme Court of the United States. Cases out of Maine, cases out of Pennsylvania, cases out of Washington. They had a common theme. And in that theme, there you can discern certain intentions and motivations. And it even relates to how, in many states, CPS is paid, how they're hired, how they're retained. But it also relates to the licensure of foster parents and how through using licensure control, another subject commonly discussed here, what the state is really up to. And you can filter all of it just through the Rekieta case. Extraordinary. This criminal case already raised interesting issues of First Amendment, Second Amendment, Fourth Amendment, Fifth Amendment, Sixth Amendment, Eighth Amendment issues, all wrapped into one. It exposed aspects of the legal news industry, the legal commentary industry, exposed aspects of the social media mindset mentality and its defects, its maddening of the crowd kind of effects and impacts. But now the nature of how stress and success can break people, the nature of drug treatment, drug addiction, drug issues, what works, what doesn't work, all of that. And now it's a crash course in what's really happening with family children's protective services in many jurisdictions. I start with a general background that nobody has ever lied to me more often, more eagerly, more easily than people who work for children's protective services. They are the worst by a long mile. There's no set of corrupt prosecutors, judges, law enforcement that has ever lied to me with the ease and with the continuation and pervasiveness that children's protective services do. I say this as someone who has represented hundreds of victims of serious neglect and abuse, not trying to criminalize working class families, as some people would like to convert children's protective services to do. But rather, I'm talking about serious abuse cases. And the biggest adversary and the worst ally in every single one of those cases was children's protective services, without fail. It's because their objective is different than what they're alleged to be. Much as the agriculture boards are out to run small farmers out of business, not make sure your food supply is actually safe, in the same way medical boards are in the big pharma protection business, not to make sure your medicines are actually safe or effective. Children's Protective Services is about the state getting control of your kids. It is not about protecting children. It never has been. It's financially structured. Its employment methodologies are all aligned to an ideological orientation along Hillary Clinton's "it takes a village." Means it's for the government to own your kids. One of the great problems that the corrupt elites have, best exemplified by the Amish, is that they don't get the degree of control over our children that they want. It's what ties in things like drag queen story time. It's what ties in teachers wanting to teach your 6-year-olds about sex. It's about control of their minds. Control their minds, you control their future. The problem is parents. Parents instruct on their own set of values. Parents instruct in ways different than these elites want these kids instructed. That's why they've disliked private schools, waged war on them in the late 1970s, religious schools, on the grounds that they're all racist, which was completely false, by the way. Helped cost Jimmy Carter the 1980 election, and at least in the South in part, because he went along with it with his professional managerial class pals at the Department of Education. The reason why Hillsdale takes no federal funds, they want no controls, they want no strings. But that has long been their goal. And they do so through social media, they do so through Hollywood, they do so through the educational system. But that is not perfect. That's why they wage war on religious parochial schools and religious institutions, wage war on homeschooling, and the other thing they do is use Children's Protective Services to try to assert the right for the state to control your child, to literally take your child away. And often they're financially incentivized. And you have three types that work. Here's their employment mechanisms and how the financial incentives play in. The people they employ fit one of three categories in my experience. A good number of them are abusers themselves. They're psychopaths and sociopaths who love power and control. They tend to relate to abusers, by the way. And they're sick puppies, to put it kindly. I was shocked when I first got into it, because whenever I had a case of actual abuse, without fail, CPS was the main adversary. When I had a case of fake abuse charges, CPS was the main ally of the fake abuse charge. It was reliable, dependable, and started to see this firsthand. And then started studying the psychology of the people I was dealing with. Noticed a lot of them fit the pattern of abusive people. They like the power. That's what they're drawn to the profession for. Second group are your social worker types who love the ideological indoctrination, who believe the state should really govern your kids. And here you can look to examples from communist countries. They really love state monopoly on the child. The state owns the child. It takes a village. It takes the government, in other words. That's what Hillary meant. The third type are just low-level, semi-competent to incompetent people who couldn't get a real job, many times got the job because of affirmative action policies, who are just looking to line their pockets. And here the financial incentives are a big giveaway as to what this system is all about. The longer you keep a kid in the system, in many states, the more you get paid. Frequently, they're subcontracted out with private contractors involved. This is true, by the way, of drug testing companies. The more drug tests, the more money they make. So they have an incentive to have more drug testing. So it creates distorted incentives that are not aligned with the best interest of a child in any instance. So in putting that in the background, the what allegedly was leaked was a sealed court order that disclosed the children's names, children's date of birth, and the children's result of medical testing. Pretty much a violation of state and federal law. Now, here is an example of where you can read between the lines. Something a lot of law tubes seemed incapable of doing. For example, the way I was able to guess the most likely nature of the search warrant affidavit before it was publicly disclosed was simply reading the arrest warrant. Now, not the arrest warrant, was reading the detention warrant and the nature of what was disclosed in there. And for that, you need sort of three things. You need to know what kind of industry standard practices are. You need to understand what the custom and practice likely is in the local area or in the area of that area in general. So you got best practices, what the real practices are. And through those two things, you can look at what should be there and what shouldn't be there. Because you're going back, you put yourself in the shoes of the officer, the judge, whomever. You're saying, well, okay, what choices did they have here? What decisions did they have here? What choices did they make? What decisions did they choose not to make? And through that, you can find a modus operandi, and from that, you can deduce fairly a motive, and from the motive, you can reasonably infer what is likely coming down the pipeline. What evidence is likely there, what evidence is likely not there. And to give a couple of illustrations, I had a case in which a client, I was going through the discovery with my client, and there was all these informant reports. And I was looking at it, I was trying to deduce who the informant was as a way to attack the credibility of certain allegations and accusations. And potentially, you could attack the search warrant, attack other things related to it. You could attack, in that particular case, the quasi-extradition deportation proceedings. That was relevant. And I couldn't figure out who the informant was because it was so weird, the combination of information they had. So I sat down with my client, started to review it. I was like, do you remember this conversation? Do you remember this? Do you remember this document? Do you remember this information? And he started giving me the roadmap. He was like, I talked to so-and-so about that. But what became clear is I talked on the phone on this one, talked on the phone on this one, talked on the phone with that one. That document was in my garage. This document was in my garage. That document was in my garage. So I started figuring out, okay, no one person had access to this. And yet they were claiming, the government, that there was only one confidential informant. And he said, oh, this here is a direct quote from my conversation with my daughter. Well, we knew the daughter wasn't an informant. So I was like, oh, they had illegal wiretaps. And then when he kept locating where the information was and the time frame was for documents that the confidential informant supposedly had got, he confirmed the documents were legit, which means they had in fact got them. And then it became clear that the only person who had access to him was someone who had access to his garage. Turned out to be his car detail man. And overlapped with the time frame. So what they had done was black bag operations using private contractors. A little sneak and peek, sometimes called. because they had got him on tax charges, the car detail guy, and said, look, we'll drop the charges, never prosecute you, if you go in and, just make some copies of documents for us while you're there detailing the car in the garage. And that's what he did. And the reason why they had used the wiretaps was in part because the cop was lazy and greedy. He wanted to build a big fancy house to impress his new wife in the Seattle region. And he didn't have time to do all the overtime, but he wanted to bill for the overtime. So he was like, what better way to do it? I'll just put up a little wiretap and listen in. And then later on, put it all together and then disguise it as an informant. By the way, they do this in the show The Wire. They cover up for The Wire, that's the name of the show, by filtering it through a bogus informant. The government does this all the time. But I was able to piece it together by looking at what's not there and what should be there. Years later, another big case that also unmasked a massive government conspiracy, extraordinary government conspiracy. And what we found was, I went through and I said, all right, let's look at these government documents and let's see what should be in those documents, how they should be organized, how they should be structured. Look at the little indicia at the top and the bottom and the little coding that's present. I use the Internal Revenue Code's own transaction code entries to do FOIA requests to figure out what should be there and what shouldn't be there in a person's IRS transactions file, which can include, by the way, whether somebody's under criminal investigation. And so in looking at it, figured out that a bunch of the reports were doctored, that they had put 2 pages of one report together with 2 pages of another report to create a fake report that told one narrative if you read it through without looking at some of the coded entries that made clear these weren't from the same set of documents. They had just completely manufactured a fake story. And a bunch of high-ranked, Sally Yates, by the way, was the prosecutor responsible for it. And a bunch of other key people were involved. And we were able to put together the scale of false accusations that had been made, the falsification of documents, falsification of testimony, the intimidation of congressmen and senators who had inquired about the case by these same rogue lead agents in Atlanta. And consequently, from all of that, was able to piece together how they had faked the case. They had actually stolen things from places they didn't have legal access to, disguised it as a random search, administrative search at a FedEx facility. They had intimidated and lied to people. Basically, the short answer is my client had just had a basic, he had built a house using his business revenues that was properly identified in his books as separate for the house because he's in construction business. So it made sense to tap all his construction contracts to build his house. And they tried to make it into a huge tax case, but it wasn't. But the way they got away with it was how they skipped all the processes for normal administrative review was they did illegal searches, illegal seizures, and they built a completely fake story that suggested that my client was connected to organized crime around the world globally and was helping Osama bin Laden. That's the scale of insanity of the fake story they produced. Because they needed to make sure no one reviewed it. But so what is, if you know what the standard industry practice is, you know what it should be there, you know what the custom and practice is of those officers or agents or agencies, then you're able to say, okay, what decisions did they make at key points? What information is in or out? And from that, infer intent and motive and modus operandi. And from that, guess what else is likely the case. So here, for example, let's just start with the leaking of the documents. The leaking of the documents is a serious crime. Who could have done it? Well, you can guess that Rekieta and his wife didn't do it. So who does that leave? That leaves only 2 people. The court and the government. In this case, Children's Protective Services. They're willing to commit a serious crime. To do what precisely? Just to shame and embarrass Nick Rekieta in the court of public opinion. I mean, there's no other benefit of this, right? Government already has the information. Court already has the information. Now, to some degree, you're getting it to the prosecutor, who otherwise wouldn't have it. But you can do that without making it public. All right? The only incentive to do it public is for public humiliation, public attack on reputation in the court of public opinion. And so all these people, like I said when I read the detention warrant, two things became clear. This cop is biased because he skipped all the procedures you normally do, knowing what industry standard practice is when a mandatory reporter makes a report. If you know what that practice is, you refer it to Children's Protective Services. They do an initial house check. There's an initial investment. That's how the process works. All of that was circumvented. That they in fact, never told Children's Protective Services at all until after they'd seized the kids at the search warrant raid. Second thing is common protocol to validate a search warrant, if you're relying upon hearsay information, is to go interview those witnesses. And particularly when it's secondhand, third-hand, fourth-hand hearsay. None of that was ever done. The other thing is if you want to interpret someone's public behavior as having a reasonable, probable evidentiary inference of illegal substance abuse, you go get someone who's an actual expert in it. It's not some small-town cop. I didn't have it either. And then you looked at what was included. So there's all the things that are omitted. Then you look at what's included. And I looked at what's included, and I saw they're talking about whether he had an affair. They're talking about him walking out of the pastor during the sermons. They're talking about whether he drives fast, right? They're talking about things that have no bearing whatsoever, but that are publicly embarrassing, potentially. So I was like, okay, this is a cop that's out to get him. That probably means this and this and this, and that's what we found in the search warrant. Same thing here. You have either the court or the government committing a serious felony just to embarrass Nick Rekieta. Ask yourself what that tells you about the mindset and the mentality there. Now you can know the complicity of the prosecutor's office, the government, the CPS, and the court real easily. Because remember what happened when a Canadian parent simply ratted out that they were trying to force trans treatment on his kid? They did everything possible to put him in prison. Right? And what was the grounds? Private, confidential, sealed records. So, if the court isn't the source, and the court is not complicit, the court would immediately issue an order to show cause for contempt as to what the heck happened. Watch, the court will never do that here. If the prosecutor was serious and not complicit, then the prosecutor would open an immediate criminal investigation into this extraordinary breach. Watch them never do it. And if CPS had nothing to do with it, they would be eager to vindicate themselves by engaging in their own investigation. They never will. It shows you have a coordinated local government willing to commit serious felonies, state and federal felonies, just to embarrass someone. Doesn't that suggest probable prejudice and bias in everything that's taking place here? Just maybe. So that's just one side of it. Then you get to the second side of it. What they often do in Children's Protective Services cases that are ancillary to a criminal proceeding is they try to sucker the parent and saying, hey, you want access to your kids? You better tell us things that can now be used against you in the criminal case. You better waive those Fourth Amendment rights. You better waive those Fifth Amendment rights. You better waive those Sixth Amendment rights. You want to see your kid, don't you? Don't you love your kid? Come on now. Be good. Give us those test results. Talk to us. We'll even think of it as off the record. Right? They do this all the time because they don't care about the kids. Nobody who gets hired at CPS cares about the kids. Not intentionally. There may be some good people who sneak through there, but you got to sneak through there to get through there. If they sense you're a real child's advocate, they're never hiring you. That isn't who they want. So in fact, because you could unravel the whole thing. Can't have any Ed Snowdens around, any Julian Assanges sniffing around. So that's once you know that aspect of how they're operating, the that's the second, you're put in an impossible position if you're a parent. Either you forfeit access to your kids, or you forfeit your defense in the criminal case. Prosecutors love this. It's one of the most abusive forms of power the state has. Deny you access to your own children. By the way, there was talk that, hey, don't worry. Clearly they would have put the kids with the grandparents. Nope. See, the next thing they do in these kind of cases is they require you to be placed with a licensed foster care parent. Think the grandparents are licensed foster care parents? Don't think so. Now, why is that? Here again, the goal, now think back to the other cases we've been talking about over the last several years. In many of these cases, what they were concerned was the denial of adoption rights, the denial of foster care consideration of people who had the wrong beliefs. If you didn't recognize gender identity beliefs, you couldn't be licensed to adopt or be a foster parent. You know what else in many states in 2020 and 2021 and 2022 also said? If you didn't believe in the COVID vaccine, you couldn't be a foster parent or an adoption agency. If you had certain religious beliefs, you were precluded and excluded from being a foster parent or adoption agency. These are state licensed officials. And this is about the state making sure they have control and custody of your kid whenever they want to. Under any pretext they can imagine and fancy up. That's what's going on underneath all of this. And that's why the court is requiring placement of all of his kids with a licensed foster care provider. The other thing they do, as was raised in one of the more liked questions today in the reply thread, is they treat the foster parent as now having control over what the kid does, what the kid's medical treatment is, whether the kid gives up their constitutional rights and liberties. So one of the first things they do is they say, well, we want to do a medical exam. We want to do a drug test. The kids have their own constitutional rights to say no. There's no basis for it. But they treat the kids like property. And the foster parents are eager to help out. Many of the foster parents that get licensed are only in it for the money and share the same they're the same ideological inclination, or sociopaths. They mirror Child Protective Services. They're either sociopaths, grifters, or ideologically aligned. Almost without fail, sadly. The ones that they choose to license. There's plenty of good people out there that seek to be foster parents, and I'm not describing them. I'm describing the ones that they prefer to license. So they're eager to help the state by any means available. They also, again, have a monetary incentive. The longer their kids are in their treatment, the bigger the checks they get. They have no interest in uniting. Even though the law says your whole focus is supposed to be uniting the child with the parent, everything that actually happens is about prohibiting and preventing that from occurring. So that's how the scheme works.